Hello friends, my name is Vishnu Abhinna and I basically come from civil service background. I welcome you all to this YouTube session on 31 probable questions on Indian polity for civil service prelims. I had also worked as an assistant professor prior to my civil service stint, and I have also been an NTSC scholar. I have brought this particular session for you to help you out in the forthcoming civil service preliminary examination. I'm sure that this is going to immensely help you because these questions I have picked up based on my long experience. I have been associated with IAS coaching and mentoring programs for almost more than 2 decades now. And several of my students are in civil service. So let us right away start with 31 probable questions on Indian polity for civil service prelims. The first question I have brought for you today is concerned with delimitation commission. The delimitation commission, this is the first question, is concerned with delimitation commission, that the delimitation commissions are so powerful that its orders have the force of law and they cannot be challenged before any court. So this statement, as you can make out, is obviously a correct statement. And the commission's orders are enforced as per the date specified by the President of India. This also is a correct statement. Delimitation commissions are established by the government based on the Delimitation Act, which is passed by Parliament. And we have had 4 such acts so far passed by Parliament in 1952, 62, 1972 and 2002. And only members of Parliament are drawn in as associate members to help the panel in its task. This is not obviously a correct statement because not merely the members of Parliament but members of state legislative assemblies also can be drawn in as associate members to help the panel in its task. So obviously here statement C is correct statement. Why was it in news? Because the Lok Sabha Speaker has nominated 15 members of Parliament from Jammu and Kashmir, Assam, Manipur, Nagaland and Arunachal Pradesh as associate members of the Delimitation Commission to assist the panel in redrawing parliamentary and assembly constituencies of the northeastern states and the union territory, particularly of Jammu and Kashmir. Now, statement 1 and 2 are obviously correct because Delimitation Commission, that is delimitation exercise as such, is undertaken by a highly powerful commission, and they are formally known as Delimitation Commission or Boundary Commission. And these bodies are so powerful that its orders have the force of law and they cannot be challenged before any court. The commission orders are enforced as per the date specified by the President of India. Statement 3 is obviously incorrect because members of Parliament and legislative assemblies as well of the states for which the Delimitation Commission is set up are drawn as associate members to help the panel in discharging its duties. So that is the first question I brought for you for the civil service as a probable question for civil service examination. I remember the government had on 6th of March 2020 constituted Delimitation Commission to be headed by the former Supreme Court Judge Ranjana Prakash Desai to redraw Lok Sabha and Assembly constituencies of the Union Territory of Jammu and Kashmir and the northeastern states of Assam, Arunachal Pradesh, Manipur and Nagaland. Now, Election Commissioner Sushish Chandra at that time and the election commissioners of Jammu and Kashmir and 4 states and the 4 states concerned, they would also be the ex officio members of the commission. So we can make out here that composition of the commission, the functioning of the commission, and the primary task of the commission is to redraw the boundaries of various constituencies for which the commission is constituted. The commission, it would delimit the constituencies of Jammu and Kashmir in accordance with the provisions of the Jammu and Kashmir Reorganization Act, which has recently been passed by the Parliament, and the state of Jammu and Kashmir has now been bifurcated into 2 union territories of Jammu and Kashmir and Ladakh and that of Assam, Arunachal Pradesh, Manipur, Nagaland in accordance with the provisions of Delimitation Act 2002. This is as per the Law Ministry notification. Now, the question number 2, which I brought for you, consider the following statements regarding the ordinance making power of the president. We know that the president of India has got these legislative powers under Article 123 of the Constitution, and president can promulgate ordinances if one house is not in session or both the houses are not in session. Now, the president can issue ordinances. This I am talking question number 2. We have to find out the correct statement. The president can issue ordinances on the subject of central list, state list, as well as concurrent list. This obviously is not a correct statement, because the executive power of the union would extend to subjects which are there in the central list and the concurrent list only. And same way the legislative powers would extend, and therefore the legislative power would not extend to the state list subjects, which is a prerogative of the states as such. So this statement obviously is not correct. His ordinance making power is not a discretionary power. Obviously, it is not a discretionary power of the president, because president in our parliamentary setup is only a titular head or a nominal head, and therefore he acts on the advice given by the Council of Ministers headed by the Prime Minister. Therefore, it is not his discretionary power. So obviously, it is not his discretionary power. So the ordinance making power is not a discretionary power. This statement is correct. An ordinance issued by him ceases to operate on the expiry of 6 weeks. This is also not a correct statement, because the ordinances which are issued by president, they can remain in operation up till 6 weeks after the reassembly of the house. That means that if the house maximum, it can reassemble after 6 months, like there can be a gap of maximum 6 months between 2 sittings of the house. So that way, a maximum gap can be 6 months and 6 weeks. So this 6 weeks basically is not by itself, but 6 weeks from the date of assembly of the house. So obviously here in the question number 2, only statement 2 is correct, as we can make out here. Statement 1 is not correct. President's ordinance making power is coextensive with the legislative power of the parliament. This means that he can issue ordinances only on those subjects on which parliament can make laws, central list subjects and the concurrent list subjects. And statement 2 is obviously correct, because the ordinance making power is not a discretionary power, and this means that he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers, which is headed by the Prime Minister. Statement 3 is also not correct, because the ordinance issued by him ceases to operate on the expiry of 6 weeks from the reassembly of parliament, or reassembly of that particular house, or a particular house, whichever reassembles first. Now, it may cease to operate even earlier than the prescribed 6 weeks if both the houses of parliament pass resolutions disapproving it, right? That means that is about the ordinance power of the president under Article 123. Remember, this is under Article 123 of the Constitution. Then question number 3 I brought for you is regarding the budget. Consists of 2 types of expenditures. That is the charged expenditure, and the other one is voted expenditure, right, upon the Consolidated Fund of India, and the expenditure made from the Consolidated Fund of India, which is voted expenditure. Consider the following statements about this. Question number 3, we have to find the correct statement. Here, the charged expenditure is non-votable by the Rajya Sabha but votable by the Lok Sabha. This is obviously a wrong statement, because charged expenditure can neither be voted by Lok Sabha nor by Rajya Sabha. Charged expenditure cannot be voted at all. It is charged expenditure primarily means that it is not subject to approval or disapproval of Parliament. It is directly charged on the Consolidated Fund of India. And the salaries and allowances of the chairman and deputy chairman of the Rajya Sabha, they are charged expenditure. Obviously, this is a correct statement. Therefore, for question number 3, D is the obvious choice. Now here, as we can make out, statement 1 is not correct, because the budget consists of 2 types of expenditures: the expenditures which are charged upon the Consolidated Fund of India, and the expenditure which is made out of the Consolidated Fund of India, or which is voted rather. The charged expenditure is non-votable expenditure by Parliament. That is, it can only be discussed by the Parliament, but it cannot be voted, while the other type has to be voted by Parliament. So statement 2 obviously is correct here. The list of the charged expenditure basically involves the emoluments and allowances of the president and other expenditures related to his office. Then the salaries and the allowances of the chairman and the deputy chairman of the Rajya Sabha and the speaker and the deputy speaker of the Lok Sabha. Salaries and allowances and pensions of the judges of the Supreme Court, pensions of the judges of High Court, right? And salaries, allowances and pensions of the C and AG, that is Comptroller and Auditor General of India, and the members and chairman of UPSC, and of course subjects like for the fulfillment of decrees or orders of the courts, charged expenditure is there. Whatever expenses required there, that is charged expenditure, and also in order to serve the debt charges, right, of the government, that is also charged expenditure. So we find that the whole lot of expenditures, they are charged expenditure and not voted expenditure. Now come to this matching question, question number 4. Consider the following articles and jurisdiction of the Supreme Court about them. First is Article 131, which is concerned with the original jurisdiction of the Supreme Court. So obviously this is correctly matching. 131 concerned with the original jurisdiction of the Supreme Court. 133 appellate jurisdiction in civil matters. So this is wrongly matched here. It is in criminal matters. 134 appellate jurisdiction in criminal matters, but it is wrongly matched here about civil matters. 135 is the powers of the federal court to be exercisable by the Supreme Court. Earlier, prior to the adoption of the Constitution, we had the federal court, right? Federal court, and the federal court's powers were to be exercised once the Constitution was adopted and subsequently promulgated. Supreme Court got these powers of the federal court under Article 135. So obviously here we can say that in question number 4, 1 and 4, they are perfectly matching. 2 and 3, their definitions have been interchanged. So here statement 1 is obviously correct because the original jurisdiction of the Supreme Court is mentioned in Article 131, 132, the appellate jurisdiction of the Supreme Court in appeals from the High Court in certain cases. And the statement 2 obviously is incorrect. Article 133 is the appellate jurisdiction of the Supreme Court in appeals from the High Court in regard to civil matters. 134 is in regard to criminal matters. And statement 4 is correct. 135, jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court. This federal court, when I say federal court, it means prior to the adoption of Constitution, it was federal court. And the powers of the federal court under Article 135 were to be exercised by the Supreme Court. 136, special leave to appeal by the Supreme Court. This is a very important article where the Supreme Court can grant a special permission for appeal against any judgment of any court in India. 135, review of jurisdiction or orders by the Supreme Court. 138 is enlargement of the jurisdiction of the Supreme Court. 139, Parliament can confer on the Supreme Court the powers to issue writs. Already writ jurisdiction is mentioned in Article 32, but Parliament can confer on the Supreme Court these powers to issue writs like habeas corpus and mandamus and certiorari and quo warranto for any purpose, right? That is given in Article 139. Now, students, consider question number 5, which is another important question for the day for the forthcoming examination. The following statements with reference to the Supreme Court of India. I'm talking of question number 5, and we have to find the correct statements. It succeeded the Federal Court of India established under the Government of India Act 1935. This obviously is a correct statement. Its jurisdiction is comparatively lesser than that of the erstwhile Federal Court of India is a wrong statement because the jurisdiction of the Supreme Court is larger, much larger than the Federal Court, because the appeals from Federal Court could be made to the Privy Council of the King or Queen of England. That Privy Council was there in London. So that time, that was the highest court of appeal, even higher than the Federal Court. But now, after independence, is the Supreme Court of India, which is the highest court of appeal. So the jurisdiction of the Supreme Court is not lesser, but rather greater than the erstwhile Federal Court of India. This statement is obviously wrong. And then question number 5, we are talking about only Parliament can increase the strength of the number of Supreme Court judges is obviously a right statement. So here you'll find that B is the correct statement. Statement 1 is correct. The Supreme Court of India was inaugurated on January 28, 1950, and it succeeded the Federal Court of India, established under the Government of India Act 1935. Statement 2 is not correct because jurisdiction of the Supreme Court is greater than that of the erstwhile Federal Court of India. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. Before 1950, the British Privy Council had the jurisdiction to hear appeals from the Indian Federal Court. So the Supreme Court has the power both of the Federal Court of India as well as the British Privy Council. Now, statement 3 is also correct because the Indian Constitution under Article 124, Clause 1, it states that there shall be a Supreme Court of India consisting of a Chief Justice of India and until the Parliament may by law prescribe a larger number and not less than 7 other judges. So at the beginning of the Constitution, it was 1 Chief Justice of India and 7 other judges, so total 8 judges. But now, of course, we know that it is 1 plus 33 other judges, so there are 34 total number of judges in the Supreme Court. Thus, it empowers the Parliament exclusively to increase the strength of the number of judges in the apex court. Now, students, the next question I brought for you for this forthcoming civil service examination with reference to Pradhan Mantri Jan Arogya Yojana. Consider the following statements. I'm talking of question number 6, where we have to find the correct statements. It's a flagship scheme under Ayushman Bharat, of course. It aims to provide free coverage of up to 5 lakh per family per year for primary and secondary medical care. Now, here it doesn't provide for primary medical care, it provides for secondary and tertiary medical care. That means the referred cases from the primary health center and then further referred cases from the city hospitals or district hospitals to specialist hospitals. So obviously this statement is not correct. There is no cap on the family size and the age of the members to avail the facilities provided under the scheme. Obviously this is correct. So for the question number 6, C is obvious choice. And here statement 1 is correct. Pradhan Mantri Jan Arogya Yojana is one of the 2 flagship initiatives of Ayushman Bharat under the Ministry of Health and Family Welfare. Right, this is a great initiative. Statement 2 is not correct because Prime Minister's Jan Arogya Yojana aims to provide free coverage of up to 5 lakhs per family per year at any government or even empaneled private hospital all over India for secondary and tertiary medical care, that is referred cases, right? And then these tertiary cases, they are referred cases to the specialist hospitals in case if the secondary care also doesn't work. Right, it is a health insurance scheme which would benefit 10.74 crore poor families identified through socio-economic census database. Statement 3 is obviously correct because there is no cap on the family size and age of the members to avail the facilities provided under Prime Minister's Jan Arogya Yojana, and it aims to provide the universal access to good quality health care services without the burden of financial hardship on particularly the poor families of India. So this is a great initiative by the government. Now, next one is question number 7. In the Indian legislature, right to move a motion for an adjournment of the business of the house. I'm talking of the adjournment motion, which is a very important motion, right? When the normal proceedings of the house are adjourned and attention is drawn on a specific subject. So should not, the language says that this motion should not deal with any of the matters that is under adjudication by the court. Obviously, it should not deal with any matter that is under adjudication by the court, and should not raise a question of privilege. Obviously, it should not raise a question of privilege. It should not be restricted to a specific matter of a recent occurrence. This is a wrong statement because it should be restricted to a specific matter of recent occurrence. So obviously here, as we can find in question number 7, the correct choices are 1 and 2, that is C is the correct option here. The right to move a motion for an adjournment of the business of the house is subject to the following restrictions. Now, it should raise a matter which is definite, factual, urgent, and of public importance in the first place, and it should not revive discussion on a matter that has been discussed in the same session earlier, and it should not deal with any matter that is under adjudication by a court of law, and it should not raise any question that can be raised on a distinct motion. It should not cover more than one matter at a time, and it should be restricted to a specific matter of recent occurrence and should not be framed in general or vague terms, and it should not raise a question of privilege. That means a general motion is subject to several conditions. Now, students, I briefly talk about various products we are offering, Unacademy is offering. So to say that these products of 1 year, 2 year, and 3 year subscriptions you can find now at a highly subsidized prices, highly discounted prices. So this is high time for you. Remember, my referral code is VI10. VI10. Of course, this is not Vodafone Idea, but this is Vishrut. My name is Vishrut Avinna. So from there it comes VI10. If you use this code, you are entitled to have a number of benefits on our platform. You will unlock a number of benefits. It's high time for that. You can do that. And of course, now price hike is on the anvil. So this is high time for you to actually chip in and subscribe to our courses at the earliest. And 1 year batches, they are all starting already 15 September. And now you can make out that 7 months plus 2 months plus 3 months, that is 12 months journey is broken up into distinct stages, so as to make sure that you are eventually selected, right, or you have high probability of selection at least. Comprehensive batches for 2022 and bilingual batches, bilingual as well as English batches starting from 15th September on all the core subjects. As you can make out, all the optional subjects are here. 2 year batches too starting 15 September, and 2 year subscriptions, they have, so to say, a wider package with a number of benefits involved. Similarly, for 2023 bilingual and English batches, they're starting 25th of September. You can have better interface with our educators, and specific days and timings are allocated for that purpose. You can have better preparation of the subject for that matter. And then also, like if you are short of money, then you can have 0% interest rate. At this 0% interest rate, you can have money. It's processed online in very less time, and there are no hidden charges, right? So that great facility is also being provided by Unacademy now. Then of course 20 books on 1 year plus subscription you get for free, which is worth more than 10,000 rupees. Plus UPSC Combat. Now every Sunday at 11 a.m. this Combat program is there. You can win scholarships up to 4 crores of rupees. And this is a great opportunity for all of you who want to prepare for civil service examination. So students, let's carry forward to question number 8. Now, any member of parliament who is not a minister, first come to question number 8. Consider the following statements regarding private members bill, right? The admissibility is decided by the chairman for Rajya Sabha and the speaker of the Lok Sabha. Obviously, if it is a private member's bill, its admissibility is decided by the presiding officer of the House. So this is obviously a correct statement. The member must give at least 15 days notice before the bill can be listed for introduction. This is obviously wrong statement because 30 days notice is required, 1 month's notice. While government bills can be introduced and discussed on any day, private members' bills can be introduced and discussed only on Saturdays. This is also wrong statement because it is not on Saturdays but Fridays. So obviously here, question number 8, only option A is right. Statement 1 is correct. So any MP who is not a minister is referred to as a private member, and statement 1 is correct. The admissibility is decided by the chairman for the case of Rajya Sabha and the speaker for the case of Lok Sabha. The procedure is roughly the same for both houses. Statement 2 is incorrect. The member must give at least 1 month's notice before the bill can be listed for introduction, and the House Secretariat examines it for compliance with the constitutional provisions and rules and regulations on the legislation before listing of the bill. And statement 3 is also incorrect, means not correct. While the government bills can be introduced and discussed on any day, private members' bill can be introduced and discussed only on Fridays. Now come to question number 9. The union government shall have executive powers to give directions to the states as to the administration of scheduled areas. The scheduled areas governance is highlighted in Schedule 5 of Indian Constitution. The administration of scheduled areas and scheduled tribes is mentioned there. And the Tribes Advisory Council shall advise on such matters pertaining to the welfare and advancement of the scheduled tribes in the state as may be referred to them by the president. Obviously, this is not correct because it is not president but the governor. Referred to the Tribal Advisory Council by the governor, right? So obviously here, question number 9, only first statement is correct. So A is the correct choice. The governor, in the case of Maharashtra, for example, modified section 6 of the act in its application to scheduled areas of the state of Maharashtra in exercise the powers conferred by him under Schedule 5 of the Constitution. So there are special provisions existing under Schedule 5 for the scheduled areas. As we know that President has notified scheduled areas for 10 states in the country. Statement 1 is correct. Governor of each state having scheduled areas shall annually or whenever so required by the President make a report to the President regarding the administration of scheduled areas in that state, and the union government shall have executive power to give directions to the states as to administration of scheduled areas. Statement 2 is not correct because the Tribal Advisory Council shall advise on such matters pertaining to the welfare and advancement of the scheduled tribes based on the reference which is made by the governor and not the president. Come to question number 10. The state is empowered to make any special provisions for the advancement of any classes of citizens. Now this question, I'm talking about question number 10. We have to find the correct statement. The state is empowered to make any special provisions for the advancement of any classes of citizens. So this is not correct because only the backward classes or vulnerable sections of society, for them the special provisions can be made. The term untouchability has not been defined in the Constitution. This obviously is a correct statement. So for question number 10, B is the obvious choice. 1 is wrong, 2 is right. Now, as we can make out here, was statement 1 is not correct because the state is empowered to make any special provisions for the advancement of socially and educationally backward classes of citizens, not any classes, or for the scheduled caste or scheduled tribes regarding their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. Statement 2 is obviously correct because Article 17, it talks about abolishing the untouchability and forbids the practice in any form of untouchability, which is an offense. The enforcement of any disability arising out of untouchability shall be an offense and punishable in accordance with the law. But the term untouchability as such has not been defined in the Constitution, right? And of course, under the Abolition of Untouchability Act 1955, which subsequently became the Protection of Civil Rights Act 1976, this practice is completely not only abolished, but it's punishable by law. Come to question number 11. Consider the following statements. The Constitution of India does not specify eligibility requirements for the post of governor of the state or lieutenant governor of the union territories. This obviously is not correct statement because Constitution lays down the qualifications and conditions for the governor's office. The term of office of the governor and lieutenant governor is not subject to the pleasure of the President of India. So here in question number 9, we find, of course, the term of the office of the governor and lieutenant governor is not subject to because governor works at the pleasure of the president. So it's also not correct. So neither of the two statements is correct. A governor must be a citizen of India, be at least 35 years of age, and not be a member of either House of Parliament or the House of any state legislature, should not hold any office of profit. And so statement 1 is obviously not correct. Statement 2, the governor is subject to the governor holds office at the pleasure of the president. So statement 2 is also not correct. Article 157, it lays down the qualifications for the appointment of the governor, and Article 158 lays down the conditions for the office of the governor. Now come to question number 12. Consider the following statements. A High Court judge, I'm talking of question number 12, and here we have to find the true statement. A High Court judge is appointed by the governor of the state concerned who also administers oath to the judge. This is a wrong statement because a High Court judge is not appointed by the governor but by the President of India. And a person who has acted as a High Court judge cannot plead before any court in India after retirement. This is also not correct statement, because he can plead in courts which are outside the territorial jurisdiction of the concerned High Court from where he retires. So obviously here, question number 12, none of the two statements is right. So D is the correct choice. Statement 1, President appoints a High Court judge in consultation with the Governor and the Chief Justice of the High Court, and every person appointed to be the judge of the High Court shall, before he enters upon his office, make or subscribe to an oath before the Governor of the state or some person appointed in his behalf, according to the form set out for the purpose in the 3rd schedule of Indian Constitution. Statement 2 here is also obviously not correct, because as per the Constitution, no person who after commencement of this Constitution has held office as a permanent judge of the High Court shall plead or act in any court or before any authority except the Supreme Court and the other High Courts. Means he can practice in the Supreme Court, he can practice in other High Courts, right? So the statement 2 is also not correct, as he can plead before other courts except the one where he had held charge. Come to question number 13 about the National Startup Advisory Council, which was in news. Consider the following statements about that. Now here, question number 13, I am talking about, we have to find the correct option. The council will be chaired by the Minister of Commerce and Industry. Obviously, this is a correct statement. And it will consist of the official members nominated by the central government? No, only non-official members will be nominated by the central government. This is not correct. The term of the non-official members of the Startup Advisory Council will be for a period of 1 year. No, it will be for 2 years. As we know, this is also not a correct statement. So for question number 13, the obvious choice is A, where only statement 1 is right. Statement 1 is correct. Council will be chaired by the Minister for Commerce and Industry, but 2 is not correct. It will consist of non-official members to be nominated by the central government from various categories like founders of successful startups, veterans, and the persons capable of representing interest of the incubators and accelerators, etc. Now come to composition of the council. Startup Council Chairman, Minister of Commerce and Industry. Convener of the council will be Joint Secretary, Department for the Promotion of Industry and Internal Trade. Ex-officio members would include the nominees of the concerned ministries and departments and organizations not below the rank of Joint Secretary and above. That is, non-official members to be nominated by the central government from various categories like founders of successful startups, veterans, like even this Unacademy is a successful startup, who have grown and scaled companies in India, persons capable of representing the interest of investors into startups, etc. In the term of the non-official members would be for a period of 2 years, not 1 year. Now come to question number 14. Consider the following with reference to the 73rd Constitutional Amendment Act. And here we have to find the suitable code. The Act gave constitutional status to the Panchayati Raj institutions. Obviously, this is a correct statement. We are talking of 73rd Constitutional Amendment Act 1992. And this Act has added a new directive principle of state policy to promote the self-government. This is not a correct statement, because already Article 40 was existing as directive principle of state policy for the state to promote and establish Panchayati Raj institutions for local village self-government in India. And I'm talking of question number 14. So obviously now the Act institutionalizes planning at the local level. Of course, now district planning committees are there. So 1 and 3 are obviously correct choices. So B is the correct option here. Statement 1, this means that the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Obviously, this is the right statement. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depends on the will of the state government anymore. And there will be a larger uniformity. Of course, we know that there has been a larger uniformity afterwards, because after constitutional recognition of Panchayati Raj institutions, there has been a considerable improvement in these institutions' functioning and powers. Statement 2, The Act has given practical shape to Article 40. Obviously, there already existed Article 40, which already existed, and the Statement 2 is not correct. Which says, Article 40 says, the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as the units of self-government. This article forms a part of the directive principle of state policy, which is of course non-justiciable, but now after constitutionalization, this has got a higher pedestal recognition as a constitutional recognition. Statement 3, the creation of the district planning committee to consolidate plans prepared by the Panchayati Raj institutions and urban local bodies together is a clear validation of the statement that there is a better and consolidated planning at the local level as a result of district planning committees. Come to question number 15. Students, consider the following statements about Sustainable Development Goals, India Index. I'm talking of question number 15, and we have to find the correct choice. It is developed by Ministry of Environment and Niti Aayog. This is obviously not a correct statement. Of course, Niti Aayog is there, but Ministry of Environment is not there. Designed to help leaders and change makers evaluate their performance on socio, economic, and environmental parameters. Obviously, this is the intent behind that, and the index has been constructed spanning across all 17 strategic development goals. So obviously, question number 15, we find that statement 1 is not correct here. Here only statement 2 is correct. Statement 1 is not correct. It has been developed by Niti Aayog in collaboration with the Ministry of Statistics and Program Implementation, United Nations chapter in India, and the Global Green Growth Institute, right? Statement 2 is obviously correct. It tracks the progress of all states and union territories on a set of 100 national indicators derived from the National Indicator Framework. It measures the progress on the outcomes of interventions and schemes of the Government of India designed to help leaders and change makers to evaluate their performance on socio-economic and environmental parameters. Now come to which of the following differentiates between a private bill and a public bill. A private bill can be proposed only to the Council of Ministers, private bill can be proposed only to the Council of Ministers, whereas a public bill is a draft of the proposed law. This is obviously wrong. A private bill is not disclosed to the public. This is also obviously wrong. A private bill is related to non-public goods and commercial aspects. This is also all wrong. A private bill is introduced by a non-minister, whereas a public bill is introduced by a minister. This is obviously the correct choice in question number 16. So then come to D is obviously the correct choice. A member of parliament other than a minister, which is not a member of government, is known as a private member. A bill initiated by any such member is called private member's bill, and there are certain restrictions on the introduction of a private member's bill. Rajya Sabha and Lok Sabha, as also in other state legislatures, a particular day every week is set aside for transaction of private members' bills. In Rajya Sabha, for example, 2.5 hours, right from 2:30 p.m. to 5 p.m. on every alternate Friday are generally allotted for the transaction on private members' legislative business. Come to question number 17. Which of the following constitutional provisions came into force on November 26, 1949, the day of adoption and enactment of the Indian Constitution? The right to constitutional remedies? No. The separation of executive from the judiciary? No. The oath or affirmation by the president? Yes. So this particular article had come into existence, Article 60, right? It talks of, I'll mention which all articles were adopted on 26th of November, right? Joint sitting in Parliament under Article 10? No. So obviously C is the correct choice here. Now the provisions, some provisions of the Constitution pertaining to citizenship elections, elections and provisional Parliament, temporary and transitional provisions, they including short title, they were contained in the beginning itself. They came into force on 26th of November 1949. Articles 5 to 9, all 5, 6, 7, 8, 9, all pertaining to the citizenship. Article 60, that is presidential oath. 324, that is Election Commission of India. 366, consent with definitions. 367 with interpretations. 379, 380, 388, 391, all omitted, abolished. 392 about the I show title of the Constitution, 393 about commencement of the Constitution, 392 about the power of the President to remove difficulties, 392, 393 about the show title, and 394 that is commencement. So that way 15 plus 1, that is total 16 articles came into existence that day. Now option C is correct. Article 60 provides that every president and every person acting as a president or discharging the functions of the president shall, before entering upon his office, make and subscribe in the presence of Chief Justice of India or in his absence the senior most judge of the Supreme Court available an oath or affirmation, right, in a format which is prescribed in Schedule 3 of Indian Constitution. The remaining provisions of the Constitution, they all came into force along with these provisions on the Republic Day, that is 26th of January 1950, the first Republic Day. So then come to question number 18. Students, consider the following statements about the Uniform Civil Code in India. Uniform Civil Code. The original Constitution of India did not contain provision for making Uniform Civil Code. This is obviously a wrong statement because Article 44 specifically talks about Uniform Civil Code. And Goa and Sikkim are the only Indian states to have a Uniform Civil Code in the form of common family law. This is also a wrong statement because Goa is the only state, not Sikkim. Therefore, this is also wrong. So neither statement 1 or 2 is right. So obviously D is the correct choice here. Article 44 has provisions for Uniform Civil Code. So statement 1 is not correct. Goa has a common family code, which is the only Indian state to have a Uniform Civil Code. Civil Marriage Act 1954 that permitted any to have a civil marriage outside the realm of specific religious personal law. Personal laws were first framed during the British Raj, mainly for Hindus and Muslim citizens. So statement 2 is not correct, obviously. So come to question number 19. Consider the following statements regarding sample registration system, bulletin, and news. Now, what is that? Question number 19 I am talking about. That is, it is a demographic survey. Obviously, it is a demographic survey for providing reliable annual estimates for infant mortality rate, birth rate, death rate, and other fertility and mortality indicators at the national level only. Obviously, this is a correct statement. The decline in death rate has been steeper in urban areas. No, this is wrong because the decline in death rate has been steeper. The decline has been steeper not in urban areas, and the Chhattisgarh has the highest death rate, while Haryana has the lowest. Delhi has the lowest death rate, right? Now, it has been released by the Registrar General of India under the Ministry of Statistics and under the Ministry of Home Affairs. So this is also wrong. So obviously, statement 1 only is right. So in the question number 19, as we can make out, C is the right choice. As you can see here, talking of the sample registration system bulletin, sample registration system demographic survey to provide reliable annual estimates of infant mortality rate, death rate, and other fertility and mortality indicators at the national and the subnational level. Statement 2 is not correct. Death rate stood at 6.2 in 2018 and 14.9 in 1971. Best and worst, Chhattisgarh has the highest death rate, while Delhi is the lowest. Decline has been steeper in rural areas, and the last decades, that some figures I have given here, you can check out on that. Statement 3 is not correct. It has been released by the Registrar General of India under the Government of India Act, Ministry of Home Affairs. Now come to question number 20. It's about the Rashtriya Vayoshri Yojana. Consider the following statements. Rashtriya Vayoshri Yojana is a centrally sponsored scheme. Now, it is a central sector scheme, fully funded by the center, launched by the Union Ministry of Health and Family Welfare. So statement 1 is wrong. It is a scheme for providing physical aid and assisted living devices for senior citizens belonging to BPL categories. This is the intention of the scheme. Beneficiaries of the scheme have to be aged for more than 60 and not 80. So this is also wrong statement. So obviously only statement 2 is correct. D is the right choice of this. And statement 1 is not correct. Rashtriya Vayoshri Yojana is a central sector scheme, not a centrally sponsored scheme. Fully funded by the central government, it is launched by the Ministry of Social Justice and Empowerment, and its scheme will be implemented through the sole implementing agency, that is ALIMCO, Artificial Limbs and Manufacturing Corporation of India, which is a public sector undertaking under the Ministry of Social Justice and empowered. Now come to why this was in news, because this Social Justice and Empowerment Ministry has informed about the implementation of Rashtriya Vayushree Yojana, the key points of which I already discussed with you, and it provides assistive devices like walking sticks and elbow crutches and tripods and hearing aids and wheelchairs and artificial dentures and spectacles to eligible beneficiaries who belong to the below poverty line category families, right? And Alimco is the public sector undertaking which is implementing this entire scheme. Come to question number 21. Darbar move in the news recently is concerned with Jammu and Kashmir, that is concerned with the shifting of capital for half the month at Kashmir and half the month at Jammu, half the year at Kashmir and half the year at Jammu. So Darbar move, obviously B is the correct choice here. Darbar move is a century old practice which the government functions for 6 months each in the two capitals of the state, Srinagar and Jammu. And it was in news because the High Court has now asked the centre to take a final call on the continuation of the Darbar move, which was 148-year-old practice, basically, shifting capitals annually between Srinagar and Jammu. And of course, this practice was started by Dogra ruler Maharaja Ranbir Singh in 1872, who was the third son of Gulab Singh, the founder of the Jammu and Kashmir state. So then come to question number 22. Consider the following statement with respect to Anuradha Bhasin versus Union of India case 2020. That is in the aftermath of Jammu and Kashmir reorganization. Now, this case is very important. Now, the court declared, I'm talking question number 22, court declared that the freedom to practice any profession or carry on any trade, business or occupation over the medium of internet enjoys constitutional protection under Article 19(1) G. Yes, that's correct. Such freedom being part of the fundamental rights is absolute. No, it is not absolute. It is also subject to various restrictions. So obviously here only statement 1 is correct. So A is the right choice, as we can make out here. In the Bhasin case, Anuradha Bhasin case, the court declared that the freedom of speech and expression and the freedom to practice a profession or carry on any trade, business or occupation or the medium of internet enjoys constitutional protection under Article 19 Clause 1 Subclause A and Article 19 Clause 1 Subclause G respectively. And 2 is not correct, that such freedom is not absolute. Restrictions imposed on it should be in consonance with the mandate under Article 19 Clause 2 and 19 Clause 6 of the Constitution. Inclusive of the test of proportionality. That means that only to the extent required it should be imposed and not beyond that. That's the meaning of test of proportionality. So Article 19 I have given. Now the 6 freedoms here I have mentioned. Then the restrictions imposed on Article 19A, Clause A, given in Clause 2 here, Subclause A of Clause 1, given in Clause 2 here, and the restrictions on Subclause G of Clause 1, given in Clause 6 are also mentioned here. Now come to question number 23. Which of the following are correct about collective conscience in news sometimes? Now, I'm talking question number 23. It is a fundamental sociological concept that refers to the set of shared beliefs, ideas, and attitudes and knowledge that are common to a social group of or society, obviously. And it was first used by the Supreme Court in 2017 judgment of December 2012 Delhi gang rape case. Now, this is not correct because it had been used earlier also by the Supreme Court. So, obviously, here in the case of in this particular case, A is the right choice. Evolution of the collective conscience of society as a ground to justify death penalty was first used by the Supreme Court in 1983 in Machi Singh versus State of Punjab case. Court held that when the collective conscience of society is shocked, it will expect the holders of the judicial power center to inflict death penalty. So that is the rationale, that's the context behind collective conscience idea. And subsequently, of course, court used it in cases involving serious crimes. Then come to question number 24. Consider the following statements. Parliamentary committees, I'm talking question number 24. We have to find which statements are incorrect here, means not correct here. So here question number 24, parliamentary committees draw their authority from privileges of parliament members only. This is obviously wrong statement. The standing committee's existence is uninterrupted and usually reconstituted on an annual basis. This is a correct statement. Parliament is bound by the recommendations of these committees. No, the Parliament is not bound by the recommendations of these committees. This is also not correct. So 1 and 3 are not correct statements. B obviously is the correct choice for this. Statement 1 is not correct because parliamentary committees draw their authority from Article 105 on privileges of parliament members and Article 118 on parliament's authority to make rules for regulating its procedure and conduct of its business. Statement 2 is correct. Standing committees, their existence is uninterrupted usually, and they are usually reconstituted on annual basis. Statement 3 is also not correct. Bills that are referred to committees are returned to the House with significant value addition. However, Parliament is not bound by the recommendations of the committees. Now, there are so many standing committees, financial standing committees, department related standing committees, other standing committees. 24 department related standing committees are there, and these financial committees are there, and there are lots of other standing committees are there, which I have highlighted here. You can peruse them, go through them subsequently, right? Then some ad hoc committees are also there, which I have highlighted here, that you can go through subsequently. Come to question number 25. Consider the following statements about the Office of the Comptroller and Auditor General of India, C&AG. I'm talking question number 25, and here his constitutional status in the table of precedence is same as that of the Supreme Court judge. Obviously, it is not same. C&AG is placed one rank below, that is 9 and 9A, that is the difference. And reason, he can be removed in the same manner as that of a Supreme Court judge. So obviously this is correct statement. So here for question number 25, C is the obvious choice. The A is incorrect, but R is correct. It is important to note that the table of precedence is not mentioned in the Constitution of India. It was issued in a notification in the year 1959 by the central government. This table of precedence as such is no official standing, but it's used in sitting arrangements and honorary protocols during official ceremonies and functions. So let's come to the next question, that is question number 26. Which of the following amendments to the Indian Constitution empowers the President to send back any matter for reconsideration by the Council of Ministers? Obviously, this is the 44th Constitutional Amendment Act. This is, answer is D. 42nd Amendment Act, Article 74(1) stated that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. However, there was a slight ambiguity whether the advice of the Council of Ministers is binding on the President or the 42nd Amendment Act made it explicit that the President shall act in accordance with such advice. However, subsequently, in 1977, 44th Amendment Act added that President can send the advice back for reconsideration once. But if the Council sends the same advice again, the President has no other option but to go by it, means accept it. So the amendment went into effect on 20th of June 1979. Now question number 27, come to question number 27, where the district and sessions judge in a state works directly under the control of which of the following authorities? District collector? No. State governor? No. State law minister? No. Choose the correct answer. So obviously none of the above, because here we can make out the district courts as subordinate courts that work under the authority of the High Court and eventually the Supreme Court. Immediate control is exerted by the High Court and final control by the Supreme Court. So the High Courts are responsible for appointment, posting, transfer and general administration of the district courts. The district courts are free from interference by the state or central executive. Come to question number 28, students. This is an important question I am giving you. Consider the following about the National Capital Territory of Delhi. I am talking about question number 28, and we have to find the correct code. All the members of Legislative Assembly are chosen by direct election. Yes, this is right. 70 members of the Legislative Assembly of Delhi are chosen by direct election. The laws of assembly on municipal matters prevail over those made by the parliament. This is wrong statement because parliamentary law prevails in that case. Chief Minister of the NCT of Delhi is appointed by the Lieutenant Governor. This is also wrong because he is appointed by the President. This is also wrong statement. The size of the Council of Ministers is decided by the Lieutenant Governor. This is also wrong because the Act mentions its size to be 70. Though the order issued by the Union Ministry, no, so this is wrong. So obviously we can make out here question number 28, only first statement is correct. So A is the obvious choice. Statement 1, special provisions for Delhi are created by 69th Constitutional Amendment Act 1991 under Article 239AA and 239AB. The strength is fixed at 70 members in case of Legislative Assembly, directly elected by the people. Second statement, Assembly can make laws on matters, all the matters of the state list and concurrent list, except the matters, except three matters in the state list, that is police, public order and land. But the laws of Parliament prevail over those made by the Assembly. Chief Minister is appointed by the President and not by the Lieutenant Governor, and the other ministers are appointed by the President on the advice of the Chief Minister. Remember, it is a union territory. The strength of the Council of Ministers is fixed at 10% of the total strength of Assembly, that is 7, one Chief Minister and the 6 other ministers. Question number 29, students, is about the term cooperatives and cooperative societies can be found in which part of the Constitution. So here, now, Part 3, fundamental rights, it is found. Part 4, directive principles of state policy, it is found. Obviously, it is not found in fundamental duties. So A and B, so D is the obvious choice here. As we can make out, 97th Amendment Act gave constitutional status to protection of cooperative societies. And here, it made the right to form associations, unions or cooperative societies as a fundamental right under Article 19, Clause 1, Subclause C, and included in Directive Principles of State Policy on Promotion of Cooperative Societies, Article 43B, and it added a new part, 9B, in the Constitution, which is entitled the Cooperative Societies. Now, students, question number 30 is about the Union Public Service Commission. Question number 30 I am talking about, and we have to find the correct codes. That Constitution has not specified the strength of the commission, has left it to the discretion of the President. This is obviously a right statement. No educational qualifications are prescribed for the commission's membership. This is also correct statement. Educational qualifications are not prescribed. The members of UPSC can be removed only on the grounds and in the manner of removal of Supreme Court judge. This is obviously wrong statement because President can remove them if they are found unfit or infirm or not capable of discharging their duties, and also they can be removed for misbehavior after a Supreme Court inquiry, right? So students, here question number 30 we are talking about 1 and 2 obviously are correct choices. Option A is right. Here statement 1, the UPSC consists of a chairman and other members appointed by the President of India. The Constitution, without specifying the strength of the commission, has left the matter to the discretion of the President. However, generally there are 9 to 11 members including the chairman, and qualifications are no qualifications are prescribed for the commission's membership, except that one half of the members of the commission should be such persons who have held office for at least 10 years under the government of India or government of a state. Then of course the President can remove the chairman and members of UPSC on grounds of insolvency, etc., insolvency or infirmity of mind, etc. On the ground of misbehavior, they can be removed only after an inquiry by the Supreme Court, which is binding on the President. Last question of the day, students, is about the Advocate General in the state. Question number 31. Advocate General is appointed by the President in consultation with the Chief Justice of the High Court. This is obviously a wrong statement because he is not appointed by President but by the Governor. He is the chief law officer of the government in the state is correct statement, and he may not be a citizen of India is obviously wrong statement. So obviously B is the correct choice here. The Advocate General is appointed by the Governor, not by the President. He must be a person who is qualified to be appointed as a judge of a High Court. In other words, he must be a citizen of India and must have held a judicial office for at least 10 years or been an advocate of a High Court for 10 years, right? Or in succession, a number of High Courts put together. Now, as Chief Law Officer of the government in the state, the duties of the Advocate General that include to give advice to the government of the state upon such legal matters which are referred to him by the Governor, and to perform such other duties of legal character which are assigned to him by the Governor, to discharge the functions conferred on him by the Constitution and other law. And in the performance of his duties, the Advocate General is entitled to appear before any court of law within the state, right? So students, that's the talk of the day. I'm sure that if you have intently listened to this talk, it is going to immensely help you in cracking the IAS examination. My name is Vishruta Vinna. I'm a faculty with Unacademy, and my referral code also you remember, VI10. It will entitle you to a number of benefits on Unacademy platform. I wish you all the very best of success in examination.